Good morning. Ms. Matlangu, Dr. Belvedere, and Mr. Lecheto, can we quickly test the system? Okay, now that looks fine. Can we go to the next one? Okay, can you, yes. Mr. Lecheto, can you start? Ms. Matlangu, can you try from your side? Okay, can you remove it? Mr. Lecheto, can you try?
Mr. Romano, you say I must test.
Good morning to everybody.
Good morning, Chair.
Good morning. How are you, Honorable Swartz?
Good morning, Chair.
Very well, thank you.
Morning. How are you? How are you, Advocate?
Recording in progress.
Fine, Chair, fine.
Morning.
Thank you
Good
very
morning, Chair.
much.
Good morning, Chair.
How are you?
Well, thank you,
How are you?
colleagues.
Thank you very much. Thank you very much.
Morning.
Thank you, TPP. If we are comfortable, just to save time, maybe we should start. Welcome to everybody on the virtual platform and those who are watching from home. Honorable Swart, I know you have to go to the Chief Whips Forum today. Am I correct?
No, sir. No, Chair. I am traveling to Parliament, so I will need to leave a bit earlier. Thank you, Chair.
Okay, thank you very much.
So basically, Mr. Swart has got a standing apology. Eh? That's why you remember it.
Is that Richard the Braveheart? I am always here for a few months. Thank you, Chair.
When I just went through the presentations, it's quite clear that all the institutions have prepared extensively. And I proposed members that we adjourn at 1. But if we are not done with the presentations, very important work that needs to be reported on to the nation. But I know, for instance, the SIU, they've got an 80-slide presentation. So if we're not done by 1 o'clock, I propose that we will need to reschedule for another day, but we do not want to rush this work. Will that be in order, members?
Agree, Chair.
Thank you very much. Thank you very much. Let's also welcome the Deputy Minister of Justice, Honorable John Jeffrey. I propose that we start with Justice, followed by SIU, and then the NTPP, because I think there will be a direct relationship between what the work that has been done by the SIU and whether there has been any follow-through by the NPA. Then we will have the NTPP. Will that order be acceptable, members?
Yes. Fine.
Thank you very much. Can you start with the Deputy Minister? Over to you.
Good morning, Chair. Good morning, Chair. Good morning, members. I'd wanted to say good morning to you when you said good morning to us, but there were too many other people who were saying good morning, so I thought I would say it now. Just to say, I need to leave at 12. I have to attend a meeting with the Vice Minister of Justice from Vietnam. So if I can be excused at 12 to go and attend that meeting. Chair, I think you've seen the presentation. I would assume it would be DDG Pillay who will be presenting it. So if I can hand over to her. Thanks, Chair.
Thank you, Deputy Minister. DDG Pillay.
Good morning, Chairperson. Good morning, honorable members, Deputy Minister. Chair, Ms. Mahlangu will flight the presentation for me. And we may move on to slide 2. At the request of the committee, we are providing a presentation on those matters related to the Department of Justice and constitutional development, insofar as what is referred to in the President's response plan. May we move on to slide 3, please, Tabisile? There's quite a bit of detail insofar as what action is required, Chairperson. I'm not going to read it word for word. I'm going to provide an explanation of what was required. Starting with the first item, which is a reference to the President's response plan in paragraphs 4.4.2 and 4.4.5 related to monitoring of referrals to professional bodies. And in the first item, this relates to references related to legal practitioners that were made in the State Capture Commission report, and the work as insofar as investigating and disciplining those members who were mentioned in the report has been undertaken by the Legal Practice Council. 6 matters in total were referred to the Legal Practice Council. 2 are awaiting the outcomes of the review applications that have been brought against the State Capture Commission. 2 matters have been finalized. The LPC found no evidence of misconduct and the cases were dismissed. 2 further matters are in progress and further documents have been requested from those particular legal practitioners. With regard to 4.6.8, the establishment of a special commission of inquiry into PRASA, the action that has been described in the President's response plan is to authorize the SIU to broaden the scope of its proclamation into its investigation into PRASA based on the evidence before the State Capture Commission, and additional dedicated resources to augment the existing investigators who are also looking into these SOEs. In this regard, a broadened proclamation has not been issued as yet because a letter of support from the Minister of Transport has not been received as yet, and that is being awaited at this stage. With regard to the next page, 5.11.3, the creation of a statutory offense for abuse of powers. The Department of Justice to research possible provisions, legislative provisions for the creation of a statutory offense for abuse of power. This matter is currently under consideration in the South African Law Reform Commission, where research is being undertaken, and the write-up will be finalized by the due date, which is mid-December 2023. 5.12.5 relates to the sanction for constitutional and political malpractice. It is a similar issue related to the abuse of public power, although it's 2 separate investigations. This is also being undertaken by the South African Law Reform Commission, and the due date is December 2023. Work is currently underway there, Chairperson. 5.2.16, research into the establishment of an anti-state capture and corruption commission and public procurement agency. So based on the advice of the NACAC, which is the National Anti-Corruption Advisory Council, and the outcomes of the review of the South Africa's anti-corruption architecture by the Department of Justice, a comprehensive proposal and an effective and integrated anti-corruption institutional framework will be produced for public consultation and finalization and implementation. The department has completed its comparative research on the models followed in other countries and is preparing a proposal for a model for South Africa's anti-corruption architecture. The deadline was extended following further guidance that has been received. Draft legislation is also under consideration. Consultation with stakeholders will commence once the draft documents are finalized. Dear Chairperson, I must indicate that this work is not only that of the Department of Justice. Extensive consultation must be undertaken with the NACAC, who is also tasked with advising the President insofar as the anti-corruption architecture is concerned. Next page, 5.2.18, investigating directed to be established as a permanent entity. Here, the National Prosecuting Authority Amendment Bill has been introduced and is currently undergoing deliberation in Parliament. 5.2.19, legislative amendments for the appointment of the NDPP. The legislative amendments to introduce greater transparency and consultation in the process for selection and appointment of the NDPP drawing on the process adopted for the selection of the current NDPP. In this regard, Chairperson, the clause on the appointment of the NDPP has been removed from the bill because the appointment is mandated by the Constitution. There are also several other issues related to the broader review on the appointment of heads of entities, which will require constitutional amendments as well. And we are now considering that broader review for the appointment of heads of entities. And that clause has therefore been removed from the bill that is before Parliament. 5.2.19, financial and administrative independence of the NPA. The Department of Justice is developing a framework for engagement to enhance coordination at both strategic and technical levels and to clarify the Minister's final responsibility over the NPA as set out in Section 33 of the NPA Act and in fact in the Constitution as well. The draft document will be finalized by December 2023. 5.5.12, to amend legislation on failure of persons to prevent bribery. An amendment has been included in the Judicial Matters Amendment Bill, which is currently in Parliament. 5.5.14, to introduce legislation to allow deferred prosecution agreements by the NPA. In this regard, Chairperson, this is part of the project on the review of the Criminal Procedure Act. The project plan for the development of the reviewed and new Criminal Procedure Act has been developed and the project team established. This is currently residing within the South African Law Reform Commission in a joint project with the department. And we are also partnering with the DCS, SAPS, Legal Aid, and the NPA in this project. We are planning a second workshop to finalize the discussion document for a public participation process, which will drive the development of the bill before the end of 2023. Deferred prosecutions is part of that process. 5.7.8, review whistleblower protection laws and incentives. In this regard, the Commission referred to issues around ensuring that whistleblower protection is in line with the United Nations Convention Against Corruption, to look at a possible award of a proportion of funds recovered to the whistleblower, and whistleblowers to be afforded immunity from civil action, etc. The department released a discussion document in June 2023 with a closing date of the 15th of August 2023. Thus far, the department has presented the discussion document to certain stakeholders, namely the NACAC, the Public Service Commission, and a meeting hosted by the GIZ with civil society and the Gauteng provincial government. The comments are we've received numerous comments, substantive and comments in support of the proposals. And these comments are being evaluated, whereafter the document will be announced with a view to guide the drafting of legislation as required. That is the end of our report, Chairperson. Thank you.
Thank you, DDG. Can you take down the slides? Thank you very much. Members, are there any questions, comments? That also, I will extend this opportunity to also the NPA and the SIU if they've got anything that they want to raise on the report presented. I will note Honorable Janji, Honorable Horn, Honorable Swart, Honorable Breitenbach in that order.
Chair, I would have. Yes, thank you, Chair. I hope I'm in a bit of a noisy space. I just wanted to come in before I I get onto a flight. Just two areas I'm concerned about.
Standing
There's,
apology. Is that a standing apology?
No, not like yours.
Touche,
No, just
Stephen, touche.
just two areas. Please protect me, Chair. The first one is
I wanted to protect you, but you are an architect of your own demise.
Thank you, Chair. No, I just wanted to raise two issues of my concern. The first one is around the PRASA commission thing. I get no plausible reason why it was we're told there's, in terms of the presentation, there's no progress there because we're waiting for a support letter from the minister. I mean, what's that? This is not yesterday's work. What's holding this support letter? But beyond that, you're supposed to have that Minister of Transport being part of the team that is anchoring this. We shouldn't be told of a lack of progress as a result of a minister's inaction. So one just needs an explanation there from the team that is anchoring this. I can't accept such an explanation. And the second one, Chair, is on this integrated anti-corruption institution. It's the on the status and the reasons given. It's one area where it says nothing, basically. You don't even have timelines, and there's no indication as to where this matter is. And I think I need a better elaboration on that aspect. Thank you, Chair.
Thank you very much, Honorable Janche. Honorable Horn.
Yeah, thank you, Chair, and good morning from my side. Chair, I'm in agreement with the Honorable Janke in respect of the two issues he's raised, so I will not repeat that for the sake of time management. One additional issue I feel, however, that must also be raised is in respect of the report, in as far as I think it was 5/2/19 about the independence of the NPA. From what is in the presentation, as well as what was now shared with us during the presentation, we must, in my view, be worried that there is a disconnect between the remarks of the Zondo Commission about the importance to deal with and to establish an independent national prosecuting authority versus the envisaged work by the department and this government as set out in the presentation. None of the steps that is set out in the presentation convinces that there is truly a move to ensure the independence of the NPA. It's all well and fine to say that in terms of the appointment of the NDPP, work is to be done, and then that there is to be upscaled transparency and accountability, etc., etc. But those are only some of the elements that would come after the fact of establishing an independent NPA. And at this stage, I think we must put our concerns on the table that it would seem that a decision has already been taken that true independence is not foreseen for the National Prosecuting Authority. And if that is the case, then I think we as a committee must deal with the matter further, because I think the Zondo Commission is clear on both the necessity for a truly independent National Prosecuting Authority, and this has been an issue that has been in the public domain for very long. Thank you.
Thank you, Honorable Rothenbach.
I think you skipped me, Chair, but it's okay. Ladies first.
Oh,
No. Let
so-
Stephen go.
so-
Let Stephen go. It's fine. He's driving. Let him go.
Thank you, Chair.
Honourable-
Thank you, Chair. I just want to align myself with my previous colleagues, the concerns about the independence of the NPA from the Justice Department's presentation. And we know the recommendations came out a long time ago, the Zondo Commission, and we are dealing with an NPA bill now. So it is a pity, and that bill dealing with or purporting to deal with the permanent successor to the ID. It's a pity that we were not able to look at this aspect, independence of the NPA, understanding it would require a constitutional amendment, as the department has pointed out. But the pity now is obviously this is now going to stand over to post-elections, and that will obviously cause further delay. The second issue relates to the whistleblowers, and the timelines are also concerning there. Whistleblower protection is crucial. It was highlighted in the Zondo Commission. We know that as members of the Portfolio Committee, whistleblowers are being assassinated and they need greater protection. And it is a bit of a concern that the process is ongoing, and it seems there's consultations taking place. And again, this is only going to be attended to after next year's elections, one presumes. So I just wanted to express concerns and to ask the department, is there no way to expedite those matters? But given that Parliament itself has already, the cutoff date for legislation has passed. So that is why I'm saying that it would only stand over till post-elections next year, unless we had a committee bill dealing with this. Thank you, Chair.
Thank you. Honourable Ruytenbach.
Thanks, Chair, and good morning to everybody. First of all, I'd like to know, in the very last slide, there's reference made to an institution called the GIZ. I have no idea what that is. If I could be enlightened about what the GIZ is. Partially covered by the comments of my colleagues, and so I won't repeat that either. I'd like to know in relation to the the bill regarding the permanence of the independent directorate, whether that bill has been certified as constitutional by the Chief State Law Advisor, and if not, why not? And then I want to amplify the comments of my colleagues on the independence of the National Prosecuting Authority. We've all learned a bitter and expensive lesson regarding the independence of the NPA. And it's not just about the independence of the NDPP. We've all seen what happens when you have an NDPP who is captured. We don't want to go back there. We can't afford to repeat these mistakes. And what we're in effect doing now is we're re-establishing institutions that existed prior to state capture, were disbanded to accommodate state capture and to allow for state capture to be so successful. And at great expense, they were disbanded, and now at great expense, they're being reconstructed. And this is all the taxpayers' money, and something the taxpayers should be aware of. So police units were disbanded, specialist police units were disbanded, so regarded as elitist. Now they must be reconstructed, and all of that experience, all of that institutional know-how has disappeared, and it will have to be in some fashion reconstituted with great difficulty and at great expense. The same thing with the National Prosecuting Authority. The specialist units were either disbanded or decimated on purpose, and now they're making some sort of an attempt to rebuild them. At the same time, not providing the budget to do so. So we've seen what happens when you have an investigating directorate that works, housed within the National Prosecuting Authority. As soon as politicians become uncomfortable with such a unit, they just disband it, as they did with the DSO. Despite great opposition to the disbanding of the DSO, it was disbanded because it went after politicians, and they didn't like being bitten. So an independent directorate housed within the NPA is always going to be vulnerable to the same effect. And as long as it's housed within the NPA, it will never be independent. It will never have security of tenure. We'll never be able to fearlessly go after politicians again, because there will always be in the back of their minds this fact that if they do that, they can and possibly will be disbanded. So they need to be outside of the National Prosecuting Authority. They need to be reporting directly to Parliament. They need to have a much higher security of tenure. They need to have a much higher threshold in Parliament so that they cannot be disbanded with the ease that the Scorpions were disbanded with. And until that happens, Chair, this legislation is not going to give effect to what Chief Justice Zondo had in mind, and is not going to be a corruption-busting unit of any consequence. And everybody on this platform knows that. Thank you, Chair.
Thank you, Honorable Breitenbach. Honorable Maseko Jele.
Thank you very much, Chair. Good morning, and good morning, colleagues, and the DM and the team. Thank you, Chair, for this opportunity. Chair, most of the questions have been covered, but I can try to expand them a bit because of the tone of the presentation. Because to me, it comes out as if there's still a lot of work to be done in terms of the issues that they are raising, particularly on the issues that relate to other institutions that are not part of the department, and then also part of the department. Yes, the issue of the letter has been covered, and then also, Chair, in fact, to expand that question, I would like to know from the department as to how often do they make follow-ups on these issues, on those institutions that are not part of their department, and also which also, like those legal professional references, Chair. I don't know if maybe I said it right when I say legal professionals. Chair, and also on the issue of the failure to report the issue of bribery, I wanted to find out what is the difference maybe between reporting bribery and just crime in itself, because to me it's like the issue of bribery is crime, and maybe if we specifically talk about crime than saying bribery, yes, you can say bribery, but also the issue of reporting crime, it's also important, has to come out. I'm not sure if maybe what the department will say on that one, Chair. And then lastly, Chair, it is okay, hold on. Okay, it's on the issue of the abbreviations, Chair. Is it possible that when the department come and make presentations, when they do abbreviations, put abbreviations, it should be in bracket, but they should give the meaning of that, because when you're doing this, we suppose that it's not only us who are listening to this presentation. Some people might not know exactly what does that mean, as my other colleague mentioned earlier. Thank you, Chair.
Thank you very much. Over to you, Deputy Minister, and to your team.
Thanks, Chair. The officials can respond on most of the issues, but just to say that on the PRASA issue and the letter from the Minister of Transport, I'm not sure if DDG Pillay has information on that, or the SIU, because the SIU do the initial work, and then it's processed by DDG Pillay's section. So if they can respond on that. On the issue of, and it's been touched on by a number of people, an anti-corruption institution. You would have seen Honorable Janki says it's not, there's no timelines. The National Anti-Corruption Advisory Council is making recommendations on the matter, and when I spoke to the chair last week, were planning to have their initial report out early next year. And as DDG Pillay had said, there's joint work between the department and the Anti-Corruption Council on that. You've heard from Honorable Breitenbach her motivation on the chapter, on the issue of the location of a anti-corruption agency. I'm not sure if she regards it as something just dealing with investigations and prosecutions, but the fight against corruption is wider than that. It's also prevention. It's also issues of ensuring systemic investigations. And she has a view which I think has a lot of issues in it that need to be looked at, but I do need to stress that the Glenister judgment did not say that it had to be a completely separate body, but these are things that need to be debated. On the issue of the legal opinion, look, that's come from Honorable Breitenbach's ally, Mr. Hoffman. I mean, the DA and Accountability Now have been doing joint issues. I really don't know where Advocate Hoffman got that from. The NPA amendment bill was certified as constitutionally compliant prior to introduction by the state law advisors. I don't know if we, DDG Pillay, you can maybe respond as to whether we can release that opinion. I'm not sure of the status, but we could look at that. Then the issue of the whistleblowers is, I mean, I hear Honorable Swart, and yes, it is frustrating that things take longer than we would like them to, but the issues are complicated. And I don't know if Honorable Swart has read the document that the department published in June on whistleblowing, but I hope he has, and I hope he's made comments, or else there can be a briefing to the portfolio committee on that report and the proposals, although it's not something formally with Parliament as yet. On the issue of the independence of the NPA, well, there's two issues. As DDG Pillay had said, the President had said that there should be amendments to the legislation, but the issue we've got is can those be, because we would like to see a more transparent process as happened with the appointment of the current NDPP, where there were nominations and a panel to interview, open interviews, in fact, and so on. The issue, though, is the Constitution says the President appoints the NDPP. There's no curtailment of those powers in the Constitution. So it's an issue we'd need to look at, is does it then require a constitutional amendment, or can it be done in legislation? There were originally provisions in the NPA amendment bill on that, but were taken out, so that the focus would just be on the appointment, or on the making the investigating directorate permanent. On the other issues of independence, as Honourable Swart has, well, there's a number of issues there. As Honourable Swart has said, there's a constitutional issue of the cabinet member responsible for the administration of justice must exercise final authority over the National Prosecuting Authority. So there's that would need to be, well, the issue of the minister's relation. There's also the issue of the administrative side of the NPA and the linkage with justice, and how that should be dealt with, which doesn't require a constitutional amendment. So, Chair, I'll then hand it over to the officials. Thanks.
It's not, maybe before you do, my understanding of Honorable Breitenbach's question is that the permanence of the ID would be easily be done away with by Parliament, like it happened with the Scorpions. If it is done through an ordinary legislation, which would be passed by an ordinary majority in the House. So if I understand her challenge or her problem with the permanence of the ID, is that because of that, it would not really guarantee the independence of that institution. Am I understanding you, Honorable Breitenbach?
You have, in fact, understood me correctly. Thank you, Chair.
Thank you, Honorable Breitenbach.
Chair, obviously a body provided for in the Constitution has more security than one provided for by ordinary legislation. Although, again, it is still not entirely permanent because the Constitution is not cast in stone, and even a 2/3 majority can be obtained to amend the Constitution. And if anything is put into the Constitution, it would require a 2/3 majority. And then also the issue that would need to be looked at is the constitutional provision currently that the National Prosecuting Authority is the prosecuting authority of South Africa. So to say another body must prosecute would be something quite new. So those are all issues, as I'd said before on the introduction of the NPA Amendment Bill. Those are all issues that are quite complicated, that need to be reflected on, deliberated on, and will take time, particularly if they involve constitutional amendments. And that is why we want the National Prosecuting Act Amendment Bill passed to ensure that right now the investigating directorate has greater capacity. But the issues of, yes, look, there are obviously different narratives as to the issue of what happened to the Scorpions. The Glenister judgment does not accept both the minority and the majority some of the points that Honourable Breitenbach was making. There were real issues with the Scorpions in terms of the dual function or dual accountability of the investigators to the South African police but the overall responsibility of the NPA. In the amendment bill, the investigators in the ID will not have any relationship, structural relationship with the police. They will be accountable to the head of the investigating directorate. So it's just important to highlight that. So, yeah, Chair, I don't know if I've responded. I think the issues that Honourable Breitenbach raises do need to be considered, deliberated on. There is work being done by the National Anti-Corruption Council on that. But it's then going back to the issues on the NPA Amendment Bill. Chair, thanks.
Honourable Maseko Jele, Honourable Breitenbach.
Chair,
no, it's an old hand.
Yeah, Chair, is it possible for the officials to respond to the other issues before the members ask further questions?
I was thinking that maybe they would want to make a follow-up on the things we have raised, then we would also give the officials after they've made their follow-ups. Honourable Breitenbach.
Thank you, Chair. Yeah, so, the Minister raises, or the Deputy Minister raises a lot of issues that are difficult. Of course, they're difficult. It's not the job of Parliament to just do easy work. Creating a new corruption-busting institution is not easy. Of course, it's difficult. That's our job. We must do the difficult work. And if we don't engage on it, how will we get it done? It's no good saying that the Glenister judgment doesn't require an independent body. Of course, it does require an independent body. The STIR's criteria are very clear. And there's no point in trying to reinvent an old wheel. If we're going to do this job, let's do better than we did the last time. We must learn from our mistakes. So I don't understand this reluctance to engage with a body outside of the NPA. We've already learned that the body inside the NPA does not work. So, this reluctance to engage with new things and amendments to the Constitution is in my view, just nonsense. And to suggest that myself or Mr. Hoffman are collaborating to ask questions about the certification of the bill, if it has been certified, as the Deputy Minister now says, why didn't he just say so? Both of us have asked that question many times before and not received the courtesy of a reply. It would have been the easiest thing in the world to just reply to the correspondence. Thank you, Chair.
Thank you very much. Honorable GM.
Chair, I don't want to dialogue with Honourable Breitenbach, but there are issues that need to be responded to. On the question of the certification of the bill, I don't recall when Honourable Breitenbach asked that question. Maybe she addressed an issue to the Minister, but definitely in the briefing to the committee on the bill, that question was not raised. So I'm not sure what she's talking about on that. Then on the issue of an independent body, the Glenister judgment, I didn't say it doesn't need to be an independent body. What the judgment had said, it does not need to be or doesn't have to be entirely independent. It can be in the police, it can be in the NPA. So that's the point I'm making. Obviously, there needs to be independence. The Glenister judgments and the later Helen Suzman one were about the independence of the Hawks, which ultimately, which still exist because they are constitutional. Changes had to be made to the legislation to ensure greater independence, and the Hawks are in the South African police. And then Honourable Breitenbach is talking about a reluctance to engage. I'm not sure what she means on that. We're engaging now. The issue and the difference is that we want to effect changes now to the ID to beef them up. Honourable Breitenbach does not want that. She wants deliberations on the issue of the actual structure, which will not be possible to have legislated and put in effect before the elections. It requires greater work. Honourable Breitenbach, the DA has engaged the National Anti-Corruption Council. I would have hoped they would have given you a perspective of the work that they are doing, but we're not saying we're reluctant to engage. It's a question of what should be done as the first step and what are the longer term discussions that need to take place. Thanks, Chair.
Thank you very much. DJ Mashabane.
Thank you very much, Chair, and thanks to the DM and the honourable members. Just the two issues that before DDG Kale comes in, I wanted to respond to. One from Honourable Maseko Jele on how we interact with the other institutions that are affected by this matter. The presidency has set up a coordinating committee on the implementation of the Zondo Commission recommendations. So the DG of Transport or Department of Transport sits there, and in the last meeting, it was impressed on them that they need to follow up on it. And part of the reason why I think it appears on our presentation as well, when in fact it's also transport's responsibility, is that before the SIU can do any work, there has to be a proclamation, but that proclamation must be on the basis of a support from the relevant minister responsible in that area. So PRASA being part of the Department of Transport, that process can only begin once the minister and the accounting officer of transport have given a commitment, because obviously there will be cost implications to it. Secondly, it was mentioned in the presentation, maybe not in greater details, the department has been doing the anti-corruption architecture review research, which includes as well a comparative study with our neighbors in the region, in the continent, and generally in the world. And that's part of what the National
Anti-Corruption Advisory Council that the DM referred to is also working on. So they will compare what we have done and what they will want to advise the president on the institutional setup, whether there's a need for a standalone anti-corruption agency. But our understanding was that that's a parallel process to the investigative directorate process. But the review looks at many of things: corruption, prevention and corruption fighting, as well as maybe to a greater extent prosecution of corruption. So I thought I should just mention that there's a process that's going, and it might have just been taking a long time because of the international comparison that had to be done. Thank you very much, Chair.
Thank you very much. DDG Pillay.
Thank you, Chairperson. The Honourable Deputy Minister and the DG have answered a lot of the questions, but I think on the timeframes for the anti-corruption architecture, the department's deadline is the end of October, insofar as the finalization of its work is concerned. However, as I indicated, the National Anti-Corruption Advisory Council is also seized with the matter. And thereafter, I think when the department is done with its work, then there will be that process of consultation with relevant entities and with the NACA. And I understand that the deadline is February, but I can't commit to it because it's not our deadline. It's what they will be better placed to speak to. But the departmental deadline to finalize the document with the proposal to the minister is October. And that is an internal document that has not been consulted upon yet. And following the submission to the minister, then the consultation will begin. That's the one issue I wanted to raise. On the other issue with regard to the what does GIZ stands for, I think translated into English, it would be the German International Cooperation. German Development Cooperation. It's actually a German word, which is why it's GIZ and doesn't necessarily translate to the English words that I just referred to. The GIZ is engaged in work with the Department of Performance Monitoring and Evaluation, which is DPME, insofar as the implementation of the state capture reports are concerned. Then on Honourable Member Maseko Jela's question on reporting bribery and how does it differ from crime in general. The honourable members will note that the amendment that we propose is to PRECA, which also is founded upon our international obligations on the bribery convention. And the clause that we are amending is for there to be greater accountability on the part of companies to take action against corruption within their institutions, and that was found to be lacking by the Zondo Commission, and therefore the amendment. So it differs insofar as the nature of the offence is concerned, and also on our international obligations. I hope I've answered that question, Chairperson. If I've left out anything, I believe the Deputy Minister has answered the questions on whistleblower protection, and the DG has provided the background to the SIU proclamation on PRASA. Thank you, Chairperson.
Thank you very much. Members, can I suggest that Portfolio Committee on Transport with regard to the issue of the letter that must come from the Minister of Transport, they do the necessary follow on that before we adjourn. Comes back with an update on this on the issues that have been raised, and whether there would have been any work done between now and that time that we receive a final briefing from them before we adjourn in December. Will that be in order?
Yes, Chair.
Thank you very much. Any objection to that? And then can we move to the next presentation, SIU?
Good morning, Chair, Honorable Chair, and Honorable members of the Portfolio Committee. I also greet the Deputy Minister, the DG of Justice. Honorable Chair, as you indicated,
maybe before you proceed, Advocate Mutibi, maybe you should start from slide 7 or slide 8. Let's the mandate and all those things. We know that.
Yes.
Let's just start with the corruption.
That's right.
Starts, yeah.
No, thank you, Honorable Chair. We'll do exactly that, as the committee is familiar with our mandate. On slide, we start on slide number 9. My colleague, Mr. Lekgetho, is projecting the presentation. This is really just the background. When the State Capture Commission started producing the report, we immediately constituted a committee internally, which I chaired personally, and we identified matters that will be further investigated, where there is sufficient evidence to proceed with the appropriate action. We also considered matters that needed to be proclaimed, where there were no proclamations. Well, I just indicated there that the committee constituted of different managers leading different investigations related to the state capture and also the civil litigation unit. At this stage, Honorable Chair, with your permission, if I say civil litigation unit, I'm reminded that I needed to introduce, well, some of the colleagues that are joining me have been to the Portfolio Committee, but in the interest of time, I thought I would just introduce Advocate Vanara, who has joined SIU recently. He's now the Chief Legal Counsel for SIU. He'll be overseeing the civil litigation unit. Mr. Vanara, if you are able to, just to really show your face, and then I can proceed, Chair, with your permission, because we don't want him to be in the meeting and the committee is not. Are you able to do that?
I suggest that he introduces himself at the end, because we don't want you to take down the slides and.
All right.
Yes.
Okay. No, thanks, Honorable Chair. Apologies for that. I should have introduced him when we start. So we have, as SIU, also participated, and we still continue to participate in the following forums, where those forums have been constituted to deal with the implementation of the State Capture Report. We've got the State Capture Commission Steering Committee that the DG Justice referred to. It's chaired by the DG in the presidency. We continue to participate there. And then there's also a task force that has been constituted, chaired by the NPA. We participate there. And then there's a State Capture Case Management, chaired by the DPCI. There's also a project to ensure that the companies that have been identified to be on the wrong side be blacklisted, and that committee is chaired by the Department of Public Enterprise, and that also includes the directors to be pursued for delinquency process. So that part also is it's included there. Next slide, Mr. Lekgetho. Right. So the role of the SIU really is to identify matters that are highlighted by the State Capture Report and are covered by the proclamations that have been issued already, or matters that are not covered by proclamations and that requires proclamation. Then the issue about the PRASA proclamation has been covered. We also identify matters where civil litigation for cancellation of contracts and recovery of monies lost is underway, or those matters where SIU will institute civil litigation. Again, the identification of officials, executives, and directors to be held to account based on the evidence and findings. Again, by law, facilitate referrals to the NPA where evidence points to criminal offenses, and that has been done as a matter of law. Facilitate referrals of evidence of misconduct to state institutions to institute disciplinary actions. Of course, we do collaborate with all other law enforcement agencies on matters that require all of us to attend to. As I indicated, we also refer companies for blacklisting and directors for delinquency processes. And of course, there's other referrals to other regulatory authorities. Next slide. Honorable Chair and honorable members, we have identified that the State Capture Commission report has actually pointed out the state institutions where we are investigating, ESCOM being one of them, PRASA, South African Airways, Transnet, Alexco, Dinel, but there was also reference to the Free State Department of Human Settlement, which we will cover in the presentation. Honorable Chair, at this stage, I'll hand over to my colleague who is overseeing these investigations, Mr. Lekgetho, to go on now on the actual investigations and outcomes that have been reached. So we take in the approach that we need to really indicate to the Honorable Committee, the investigations in these institutions that have been pointed out by State Capture Commission report, and what is it that we are doing as investigations and the overall outcomes that we are reaching. Thank you very much. We appreciate that. Mr. Lekgetho.
No, thanks, Advocate. Thank you, Honorable Chair. Thank you, Honorable Member. And thank you, DM and DG and all the colleagues that are present in the meeting. I will be giving the progress update in all the investigation. The first one I'm going to start with is the Transnet investigation. And in terms of Transnet investigation, we have divided it into different phases. And the first phase, the SIU is looking into irregularities relating to the acquisition of the 1064 locomotive, whereby it involved 4 contracts with the original equipment manufacturer, that is OEM, to the value of 54 billion. And we are also looking at the relocation of 2 OEM from Goodiesport to Durban facility at a cost of 1.4 billion and maintenance of locomotive by CSR. We are also looking at the appointment and contracts awarded by Transnet with the 3 transactional advisors, that is McKinsey, Trillion, and Regiments. And also we're looking at the interest swap transaction, which was concluded by Nedbank. That's first phase. Then phase 2, we looked at the contract awarded to Neotel, that is for the supply of CCTV camera at the ports to the value of 882 million. And we're also looking at the software solution contracts awarded to Systems Application Product. We also look at an ICT contract awarded to T-System, South Africa. And we also look at the tandem crane procured from ZPMC. We also look at the crane procurement from LIBA. So when going to the status of the investigation, first we'll start with the procurement of the 1064 locomotive and the relocation of the building yard from Gauteng to KZN. Here, the allegation received by SIU were in relation to the procurement irregularity and price inflation in respect of the 1064 locomotive procured by Transnet from the 4 OEM. And those 4 OEM include Bombardier, and Bombardier changed its name and now is known as Alstom. Then General Electric currently is known as Webtech SA Technology. Then there's CSR. CSR is China South Rail E-Loco Supply, and now it's called CRRC E-Loco Supply. Then there's CNR, which is China North Rail Rolling Stock, South Africa, which is also changed its name now called CRRC SA Rolling Stock. Then in terms of the finding of the investigation is concluded, and currently we are providing support to the referrals that we have made, particularly on the civil litigation. And the SIU found that the contracts were awarded irregularly and the prices were inflated. In terms of the outcome, particularly on the civil recovery matter number 1, the SIU and Transnet brought the main application against the 4 OEM on the 9th of March 2021 in the High Court in respect of the contract to provide locomotive to the total value of 54.5 billion. Case civil number 2, matter number 2, SIU and Transnet have been granted a preservation order by the Special Tribunal on the 31st of August 2021 to freeze 4.2 billion held in bank accounts linked to CRRC E-Loco Supply, and SARS has a preferential claim in respect of this amount due to an earlier preservation order that they've obtained. Continue on civil litigation. Settlement discussions are underway between SIU, Transnet, and the OEM, and have progressed very well. The SIU has been consulted during this discussion, and we have provided letter of support where it's requested. And to date, two settlement agreements have been signed and supported by SIU with Webtech and Alstom for the recovery of 79 million and 365 million respectively. And if you put them together, they amount to 444 million that has been recovered. And SIU and Transnet will proceed with the pending civil litigation in order to have the irregular contract set aside in the High Court. And the parties will present the settlements to the court as the proposed just and equitable remedy. And further on the civil recovery, the SIU has noted the repayments made to Transnet to the value of 618 million by CRRC, which was a refund for an advance payment for the material and reliability support agreement. And if you add the 444 million and the 618 million, you can see that it's over 1 billion that has already been recovered pertaining to this 1064 locomotive. Then in terms of disciplinary referrals, officially involved had been dismissed and left Transnet before the SIU could start with the investigation. The second one is the appointment of Mackenzie, Trillion, and Regiments Capital, Mackenzie and Company, and also looking at those are the transactional advisors for the 1064 locomotive. Here, the allegation is that the allegation investigated were irregularity pertaining to the award of the contract to the three transactional advisor, that is Mackenzie Consortium, and also the irregular inclusion of Regiment, the escalation in the price associated with the contract, and the associated payments made to Regiment. The finding is that the SIU found that the contract awarded to this three transactional advisor was irregular. And in terms of the outcome pertaining to civil litigation, Transnet brought various civil applications in respect of the above matters before the High Court. And Regiment and Trillion and previous executive of Transnet, that is Mr. Molefe, Mr. Gama, Anol Singh, Ramos Sibudi, Thomas Gianni, and Peter, are cited in the civil recovery litigation pending in the High Court instituted in November 2018 by Transnet. Then still continue on the outcome with regard to Mackenzie, settlement agreement to the value of 870 million was signed between Transnet and Mackenzie. And on Regiment, settlement agreement was concluded with Transnet and Regiment in October 2019 for 180 million in full and final settlement of all claims. SIU is in the process of obtaining legal opinion on the validity of the settlement agreement and the prospect of setting it aside. To date, nothing has been repaid to Transnet in terms of the settlement agreement entered into with Regiment. And as we know, that Regiment is now in final liquidation. With regard to Trillion, is in the process of liquidation, which will affect the civil matters brought before the High Court by Transnet, as referred to on the previous slides. Then the next matters under Transnet is the net bank interest swap transactions in respect of the 12 billion club loan for the 1064 locomotive deal. Here, the allegation is that the interest swap transaction were irregular and not in the Transnet best interest. The finding is that the SIU found that the interest swap transactions were concluded without the required authority and not in the best interest of Transnet. And in terms of the outcome, the referrals, SIU has referred evidence to various regulatory bodies, and an investigation is concluded, and we are providing support with regard to the referrals that we have made. And SIU and Transnet have completed the court papers to bring a review application in the special tribunal to review and set aside the irregular interest rate swap transaction executed on the 12 billion loan club. And the SIU is working closely with Transnet, who are in the final stage of mediation with Nedbank to reach a settlement over the irregular interest rate swap transaction. Then the third one is the Neotel, that is the CCTV contract. Here, the allegation is that the contract was awarded irregularly. And in terms of the finding, the investigation is complete on this contract, and SIU found that the contract was irregularly awarded. The SIU investigation is ongoing on other contracts awarded to Neotel, including the master service agreement. In terms of the outcome, the civil litigation, SIU and Transnet launched a review application on 29th of May 2023 in the special tribunal and refer for the supply of CCTV camera to the value of 838 million. The SIU and Transnet are requesting the court to review and set aside the irregular CCTV contract awarded. And the SIU is participating in settlement discussion with Liquid Telecom on various matters related to Transnet, which are being championed by the AFU, and has agreed to stay the review application for a specific period to allow this discussion between AFU to take place. And with regard to NPA referrals, we have referred 49 persons that include Neotel directors, former Transnet board members, and official on the 20th of February 2022 to NPA for criminal prosecution. And in terms of disciplinary, officially involved had been dismissed and left Transnet before the start of the SIU investigation. And with regard to software solution contract awarded to system application product, it was alleged that the SAP paid undue gratification to alleged Gupta's enterprise, that is Cat House, and GSS to secure contract at Transnet in the absence of any counter performance. The finding on the investigation is that the investigation is complete into the award of the contract to SAP. The SIU found that undue gratification was paid to Cat House and GSS, and senior counsel has been appointed and briefed to recover the commission paid by SAP. SIU is participating in settlement discussion with NPA and Transnet on this contract. And in terms of the referrals, NPA referrals, One NPA referrals against 6 entities was made on the 16th of July 2021. An SIU team has also engaged with the Security and Exchange Commission investigators from America and DOJ to assist in their investigation. And in terms of disciplinary, officials involved have been dismissed and left Transnet before the start of the SIU investigation. Civil referral, SIU Civil Litigation Unit approved the institution of civil litigation, and SIU is in the process of appointing a senior counsel so that they can set aside the contract. The other contract is the Zestolo contract ceded to T-System. There, the allegation is that the T-System is alleged to have used Gupta's enterprise connection to extend the MSA by 5 years. On this one, investigation is nearing conclusion, but it's ongoing. And we can say that T-System is no longer in South Africa, and the SIU team is considering the legal avenue available to the SIU to evaluate the prospect of success in civil litigation and recovery in terms of this contract. However, the investigation is still ongoing. Then the investigation pertaining to the crane procurement from LIBA. Here, the allegation was that it was alleged that the procurement process was awarded to 2 contractors to LIBA that were irregular. And the finding pertaining to this is that the investigation is concluded and we are providing ongoing support in terms of the referrals that we have made. And the investigation is currently on civil litigation phase. And in terms of the finding, we found that the procurement process followed to award the 2 contracts was irregular. And based on the irregularity, the following outcomes were achieved. Civil recovery, LIBA offered to repay Transnet a portion of the contract value, and the SIU, Transnet, and LIBA subsequently concluded the settlement agreement on the 31st of December 2022. The settlement agreement reached was for the following: a cash recovery of 54 million for the agency fee which has been paid, and SIU and Transnet and LIBA to engage regarding the audit of the supplier development aspect of the contract to determine any further recoveries to be made, and the 3 parties will go to the special tribunal within a specified time period to set aside the 2 unlawful contracts in the special tribunal and to request the court to make the settlement agreement the just and equitable order. In terms of the disciplinary referral, officials involved had been dismissed or left Transnet before the start of the SIU investigation. And where they are involved, they will be cited in the civil proceeding. And in terms of additional matters that we are looking at, they pertain to phase 3 of the investigation. Here, the SIU investigation is investigating allegation of irregularity in respect of the following matters identified from the report of the commission. That is the Hedge-Gobodo Combined Private Investigation, the TNA Media, and the Manganese Expansion Project. This matter are being assessed for prospect of civil recoveries. Then also under still phase 3, there's a Nkonki contract and delinquent directors application. And this is the process that we are busy with the DPE, where we are trying to put together an application for the delinquency of all the directors, the board of directors, which were involved in Transnet. And we're also looking at GNS Abalozi contract, and also looking at the Gamma legal fee and the Langa attorney. And these matters are not covered by the current proclamation, and SIU have drafted a motivation which has been sent to Department of Justice so that the scope of the proclamation can be extended. That is all from Transnet, and now we'll go to SAA investigation. Then in terms of SAA investigation, the scope of the investigation in terms of the schedule of the proclamation cover the following key area: the procurement of or contracting of Airbus aircraft, maintenance, repair and operation services, legal services in terms of the following bid, and the service provider to support and expedite the implementation of the SAA turnaround plan. We are also looking at the maladministration in the affair of the SAA in relation of travel rebate benefits for qualifying beneficiary. And we're also looking at the payments that SAA made to vendors and the implementation of the SAA procurement policy. We are also looking at any irregular or improper or unlawful conduct by official or employee of SAA or any other person or entity in relation to the allegations. So when going to the status of the investigation, the first one we're going to look at is the SAA working capital, that is Mackenzie and Regiment Capital. Here the allegation is that the irregular contracts were awarded to Mackenzie Incorporate to assist SAA in unlocking the working capital of SAA. In terms of the finding, the investigation found that there was an unfair advantage given to Regiment Capital, who became a subcontractor to Mackenzie in this tender. The unfair advantage was when Mr. Petolo Ramos Sebudu provided the scope and evaluated the evaluation criteria to Regiment Capital before the tender was advertised. In terms of the outcome of this investigation, civil recovery, the SIU facilitated the reimbursement of 14 million by Mackenzie to SAA. And in terms of disciplinary, no disciplinary action referrals could be made because all the implicated officials have left the employment of SAA and are not in the employment of public services. And all members who contributed to the loss suffered by SAA, including those who left the employment of SAA, will be cited in the civil litigation process. Then in terms of criminal referrals, a referral was made to NPA Investigative Directorate, which was done on the 31st of March 2023 against one former official. Then in terms of the turnaround strategy, the allegation is that the irregular award of the turnaround strategy contract was awarded. Then the finding is that the relevant RFQ were non-compliant with the PFMA and SCM policy, as well as the applicable Treasury regulation and practice notes. The value of the contracts concluded was 170 million. In terms of the outcome, civil recovery, SIU recommended the cancellation of the contracts, which brought about a saving of 130 million for SAA. And disciplinary referrals, no disciplinary referrals action could be made because all the implicated officials left the employment of SAA. And we indicate that all members who contributed to the loss, we make sure that they will be cited in the civil litigation. And in terms of criminal referrals, a criminal referrals to the Hawks was done on the 4th of April 2019. And the AFU is involved in the civil recovery of the outstanding 40 million on this contract of turnaround strategy. Then as LSG Sky Chef contract, the allegation here is that the HF SOC Ltd is alleged to have been awarded the contract under this tender number irregularly with the interference from the former SAA chairperson, that is Ms. Dudu Muyeni. And in the process followed leading to an award of this contract to LSG Sky Chef. The process was first an open tender in which only 2 service providers responded. SAA then decided to go on a closed tender process in which they only invited service providers that are alleged to have certification from AXA. Then on the 30th of August 2015, the former SAA CEO Tuli Mche informed the SAA board about the award being made to LSG Sky Chef and the impact it will have on the HF. Then on the 3rd of September 2015, Ms. Muyeni instructed that the appointment of LSG be cancelled and the services being reinstituted with air chief. Then ultimately, our investigation found that the contract were awarded irregularly without going through the tender process. Then in terms of the outcome, the civil recovery process, LSG has instituted civil litigation against SAA, as indicated above there, that their contract was irregularly cancelled, and SIU is sourcing information to consider intervening as a party in this whole civil litigation instituted by LSG. Then on disciplinary referrals, again, no disciplinary action could be made because all the implicated officials left the employment of SAA, and we indicate that all those members, even those that who left, they will be cited in the civil proceeding as we'll be embarking on it, and no criminal evidence to support the criminal referrals could be found in this matter. Then in terms of the Airbus acquisition and Pembroke transaction, here also the allegation is that Ms. Muyeni conduct in the Pembroke transaction results in the delay in the delivery of the aircraft that costed SA approximately 800 million in pre-delivery payments. And here we can indicate that no proper explanation and evidence was given to SIU as to whether why the delivery of was delayed, and why Pembroke did not pay money to SAA as required. And the findings on this is that SAA and Airbus took a decision to discontinue the manufacturing of the last 10, the A330-200 aircraft for a swap of transaction of the five A330 aircraft. The Airbus agreement to reimburse the SAPDPs to the value of $103 million, which will be the amounting to $20 million US dollar on the delivery of each aircraft. On a letter dated 11 September 2015, the former Minister of Finance, Mr. Nhlanhlanene, approved the swap transaction. And on the letter dated 29 September 2015, the SA board chairperson, Ms. Dudu Muyeni, wrote a letter to Airbus making a U-turn on swap transaction, which was going to cost the SA extra $117 million US dollar for suspended PDPs. Then in terms of the finding, we can summarize the finding that there was no proof that swap transaction between SAA and Airbus were done through a normal procurement process. So no formal process was entered into. Then in terms of the outcome, civil recovery, potential civil recovery to the value of 824 million is currently under consideration. We are waiting quantification and confirmation from SAA regarding the exact amount refunded by Airbus. Then in terms of disciplinary referrals was made to SAA against one official on the 23rd of March 2023, and criminal referrals, potential criminal referrals is currently under consideration. Then if the PDPs were not refunded or lesser amount is refunded, we are going to do a PFMA criminal referrals against the board members. And the PDPs refers to pre-delivery payments. Then in terms of the Swiss Sport ground power units contract, the allegation is that the disposal did not follow the applicable SCM processes. And the finding is that the assets, that is ground power units, were sold by SAT at a lesser value than their book value. SAT disposed of 12 GPUs at a loss of 5.6 billion, and then leased a number of them back at a value of 550 per hour at a monthly cost between 200,000 to 250,000 per month. The outcome of the investigation is that civil recovery is in the process, and it's with the council has been appointed to recover at least 14 million. And on this aspect, quantification is still ongoing so that we can able to see how much more we can recover out of this process. And in terms of disciplinary referrals, no disciplinary referrals could be made because all the implicated officials left the employment of SAA, and they will be cited in the civil litigation. Criminal referrals was made to the Hawks on December 2019, and there is the case number mentioned there, which is case 11412 of 2019. Then on the contract of aircraft component support tender, here the allegation is that various tender irregularities, which include non-compliance with the PFMA and SCM policy, as well as Treasury regulation and practice note, and there was various corruptive relationship and payments which was made between entities, third parties, and official and board members of SAA. Then in terms of the finding, AAR's initiative came after that bid was already closed. Board member of SAT and staff visited AAR in the USA during the period that the tender was still open. 2 award submissions submitted to the board dated the same with different successful bidder. An LO letter of engagement was issued, later withdrawn, and reopened negotiation with ARR. Then in terms of the outcome, civil recovery, potential civil recovery against approximately 10 individuals and entities is under consideration, and currently we are doing the quantification. And disciplinary referrals, no disciplinary referrals could be made because the implicated official have left the employment of SAA, but they will be cited in terms of civil litigation. Then criminal referrals, there's potential criminal referrals against approximately 10 individuals and entities that is currently under consideration. Then paint tender. The allegation is that the tender was not compliant with PFMA and SCM policy, as well as the relevant Treasury regulation and practice notes. The value of this tender amounted to 19.2 million. And in terms of the outcome, this matter was concluded during the secondment. There was no enough evidence to pursue civil recovery. And disciplinary referrals, all the officials left the employment of SAA, and they will be cited, considered when we consider civil litigation. And in terms of criminal referrals, referrals was made to the Hawks in terms of the case 115/12 of 2019. Then when coming to ESCOM investigation, we look at the following contracts. The first one is Targeta Bradfontein. Here, the allegation is that the contract was awarded irregular to Targeta. And the finding is that SIU found that the contract was unlawful and invalid in that it did not comply with Section 217 of the Constitution. And the SIU made finding against various board members and executive of ESCOM. Then in terms of the outcome of this investigation, civil litigation, the contract was reviewed and set aside 3.7 billion. Future savings, which were calculated, were at a value of 2.6 billion that has been saved to ESCOM. And SIU instituted proceeding against Targeta and business rescue practitioner for just and equitable relief as a result of damages suffered due to poor quality of coal that was supplied to the value of 734 million. And this matter is currently pending in court. In terms of disciplinary action, no disciplinary action could be referred because the implicated officials have left the employment of ESCOM and are not employed in any public services. And SIU, in collaboration with ESCOM and DPE and CIPC, have prepared papers to embark on director delinquency proceeding against various former ESCOM board members. Then in terms of criminal referrals, no criminal referrals were made as the ID were already investigating this matter when we started with the investigation. Then the Targeta Optimum contract allegation also here is that the contract was awarded irregularly to Targeta, and the SIU found that the contract was awarded unlawfully and invalid, and in that it did not comply with the Section 217 of the Constitution. And in terms of the outcome, civil litigation, the contract was terminated in September 2016. The SIU instituted proceeding against the Executive Authority, Accounting Authority, Executive Management, and private individual for the recovery of 3.8 billion. And the SIU and ESCOM have been seized with defending the defending interlocutory application, which have now been disposed of. A trial date is yet to be set. In terms of disciplinary, still on these instances, officials that were implicated have left the employment of ESCOM, but they have been cited in terms of the civil litigation that is currently underway. And we're also busy with DPE and CIPC in order to embark on the process of director delinquency proceeding against various former ESCOM board members. Then in terms of criminal referral, also on this instance, ID is currently busy with this investigation, so everything is handled by the ID on this matter. Then Targeta Kwonfontein mine, the allegation here also is that the contract was awarded irregularly, and SIU finding is that the contract was unlawful, invalid, and it did not comply with Section 21 of the Constitution. In terms of the outcome, civil litigation, the contract was terminated by ESCOM based on the SIU finding, and the value of the contract was 6.5 billion. Then in terms of disciplinary referrals, we couldn't make any referrals because the official left the employment of ESCOM. And SIU, in collaboration with ESCOM and DPE, is also looking at embarking on the process of director delinquency proceeding against various former ESCOM board members. And also here, we couldn't make any criminal referrals because ID was busy with the investigation when we started the investigation. ABB International, here the allegation is that the contract was awarded irregularly. Then the SIU found that also that the contract was unlawful and invalid, and it did not comply with Section 217. And in terms of the outcome of this investigation, the SIU filed papers in the High Court on the 3rd of April 2023 to have the contract reviewed and set aside. And ABB reached out of court settlement for the repayment of 1.5 billion to ESCOM, and claim by ABB against ESCOM to the value of 1.9 billion was cancelled. In terms of disciplinary referrals here also, we couldn't make because all the officials left the employment of ESCOM and they are not in public service. Criminal referrals, SIU made supplementary referrals to NPA as the matter was already being investigated by the ID at the commencement of the investigation. And the ID issued ABB with a reparation fine of 2.5 billion. Then the Impulse International contract. Here the allegation is that the contract, there was corrupt relationship between ESCOM executives and Impulse. The investigation, the SIU finding is that the SIU investigated 2 contracts awarded to Impulse International, and both contracts were found to be unlawful and invalid and did not comply with Section 217 of the Constitution. Then in terms of the outcome, civil litigation, the contract was terminated by ESCOM, and Impulse sued ESCOM for the damage as a result of the early termination of the contract. ESCOM is defending the matter and also filed counterclaim to have the contract declared invalid. The SIU is actively assisting ESCOM in the defense of this matter. Then in terms of disciplinary, we couldn't make any disciplinary referrals because all the employees left the employment of ESCOM. Criminal referral, SIU made a supplementary referrals to NPA as the matter was already under investigation by ID. And we are also assisting ID in the investigation, and we have also seconded one member from SIU to assist ID in finalizing this matter. Then the subcontract allegation is that the 2016 subcontract was awarded as a result of corruption. And in terms of our finding, the SIU investigated the two contracts, which was awarded to SAP in 2016 by ESCOM. Both contracts were found to be unlawfully invalid in that it did not comply with the Section 217 of the Constitution. And the outcome of the investigation is that in terms of civil litigation, the SIU embarked on a civil litigation in November 2022 to have the contract reviewed and set aside. SAP filed its answering affidavit wherein certain facts were admitted to, and SAP also made an offer of settlement. The SIU has requested that the special tribunal pen proceeding pending its engagement with SAP. The SIU have rejected the offer proposed by SAP and made a counter proposal, and currently the matter is ongoing, and disciplinary referrals could not be made because all the officials who were involved left the employment of ESCOM. And criminal referrals, SIU made 13 NPA referrals, and the matter has been declared by ID, and SIU assisting ID in their investigation. And we have also seconded one member who's also assisting ID on this matter. Then when coming to the Denel investigation, the investigation was divided into two phases. Phase one, we look at the awarding of contract to VR Laser for the provision of steel fabrication of goods and steel fabrication of services. Phase two, we look at the appointment of 30 subcontractors for the provision of steel fabrication of goods and steel fabrication of services. And this matter emanates from a complaint received by SIU on or about October 2018, and some of the allegations emanate from 2019, 18-19 audit finding. Then we have a proclamation R32 of 2019, which was published on 5 July 2019. And also we've got amendment to the proclamation, which was published on the 8th of November 2019, which is proclamation R57 on 2019. Then in terms of the progress, the first contract we look at is the IT Security Assessment Service. Here the allegation is that it was alleged that in the procurement of or contracting for IT security assessment services, Denel did not follow any formal procurement or competitive bidding process prior to the conclusion of the IT assessment services. And it was also alleged further that Denel failed to follow its own supply chain management policy. In terms of the finding of the investigation is concluded, and we are providing support to the referral that we have made. And in terms of the outcome, the SIU, there is a pending civil litigation between Denel and Telspace. The litigation has been stalled due to special plea in the High Court, and has no jurisdiction. And instead, the matter should go to the arbitration in terms of the concluded contract. The SIU seek to institute civil litigation in its name at the special tribunal once the ITC report commissioned by Denel is complete and received. In that, the intended civil suit, the SIU seek to recover 4.6 million paid to Telspace. In terms of disciplinary referrals, all implicated officials left or have resigned from Denel and are not in the employment of public service. However, all the officials that contributed to the loss suffered by Denel will be included in the civil litigation process. In terms of criminal referrals, SAPS have already opened a criminal case, and SIU is providing support thereof. The second one is steel fabrication of goods, steel fabrication of services. That is the Halls contract. Here, the allegation is that Denel commissioned an investigation into 3 contracts signed with the service provider for that is namely Halls contract to the value of 229 million and 2 MOAs with service provider for all steel fabrication goods. This is an open contract, and the process was found to be fraught with irregularities. Then, in terms of the finding, all the process to appoint this service provider on all the 3 contracts were irregular, and the adjudication scores for the Halls contract were manipulated to favor this service provider. The result on the award of the 229 million Halls contract was incorrectly awarded. Then in terms of the outcomes, civil recovery, the SIU instituted a civil proceeding at the special tribunal to set aside the 3 default judgment and an attachment order for Denel IP trademark to satisfy a debt awarded in favor of VR Laser. And the VR Laser's business rescue practitioner, that is BRP, wrote a letter to SIU Council requesting to hold a meeting with a view to settle the matter. The request is currently under consideration by SIU and the Council. Then in terms of disciplinary referrals, we have referred 2 DC referrals to Denel. Criminal referrals, we have referred 7 former officials to NPA so that action can be taken against them. The next one, the third one is steel fabrication of goods against the 30 subcontractors. Here, the allegation is that DLS failed to follow its own SCM policy in appointing some of this company. Then, in terms of the finding, the investigation is still ongoing. And in terms of the outcome, civil, disciplinary, and criminal referrals, we have indicated that at this stage we can't mention anything because the investigation is currently ongoing. Number 4, steel fabrication of goods. Here we are looking at the chart contract. Here the allegation is that the chart contract, the appointment of service provider to deliver the Sino truck drivetrain chassis was awarded irregularly and to the value of 13.8 million. And the finding here in terms of the investigation is that Denel approached the service provider for the chart contract on the belief that it owned the IP, and the service provider then demanded a payment of outstanding invoices for other contracts on Denel, and Denel settled an amount of 15 million from the chart fund. After the payment was made, the service provider failed to render services and did not even sign the order for the chart contract. At least 15 million of the chart contract fund were used to settle this service provider's outstanding debt. In terms of the outcomes, the contract is referred to the special tribunal, and disciplinary referrals, we couldn't make any referrals because all the implicated officials have left the employment of Denel. However, they will be cited in the civil litigation process. And in terms of criminal evidence pointing to the Commission of Criminal Conduct is currently under consideration and will be forwarded to NPA once it's finalized. Then number 4, also looking at the steel fabrication, looking at the chart contract. Here we're looking at the allegation is that we are looking at the appointment of a service provider for manufacturing of the Casper vehicle to the value of 15 million. Here the finding is that SIU found that the appointment of this contract was irregular because the submission for deviation was based on misrepresentation. Then in terms of the outcome, civil recovery, referrals in respect of one service provider for the balance of the advance payment was made to the special tribunal. An amount considered is 12.7 billion. And in terms of criminal referrals, evidence pointing to criminality against 7 entities and individual is currently under legal review, and it will be referred to NPA in due course. And disciplinary referrals, we couldn't refer any because most of the implicated officials have left the employment of Denel. However, this official will be cited in terms of civil proceedings. The other contract, also the chart contract, also here we're looking at the appointment of technical advisor, and the amount paid is 9.7 million. And in terms of the finding here is that the appointment of the TA was found to be irregular and unlawful in that Denel did not follow its own policy, and the former GCO did not consult with the relevant department when appointing the TA's technical advisor. And in terms of the outcome, civil recovery, we have referred to civil litigation unit for them to institute a review of the contract. And currently the process is under review by legal, and the contract value is 9.7 million. And criminal referrals, we didn't make any. And in terms of disciplinary also, we didn't make any because all the officials have left the employment of Denel, but they will be cited in several papers. Then number 5, here we're looking at the contract awarded for the provision of legal service. Here the allegation is that Kampa attorney was appointed to render legal services to Denel without following proper procurement processes, and the value of the contract is 10 million. Here the finding is that the contract was irregular and no contractual agreement was signed. Fee negotiated were outside the normal SCM processes. GCO and chairperson managed and directed the project, and Denel Legal's department were not involved in the process. No record on instruction file kept by the firm of attorney, and the finding goes on and on. Then in terms of the outcomes, the civil recovery, the referral to civil litigation is under internal legal review and will be submitted to the SIU civil litigation unit soon. And disciplinary referrals, the affected officials are no longer in the employment of Denel, and then also they will be cited in civil litigation process. Criminal referrals, the evidence pointing to the Commission of Criminal Act is currently under consideration and will be forwarded to NPA soon. And administrative action, referrals of the book accounts of the law firm will be made to LPC and currently is under review. And once it's finalized, it will be referred to the LPC. Then the awarding of pilots bursary to students. Here we're looking at 3 students, and the first student, here the allegation is Denel awarded bursary to student number 1 for a jet pilot program, who signed a bursary agreement on the 1st of February 2017 to the value of 1.1 million. And this contract was in breach of the Denel SCM policy. Here we have found that the bursaries were issued irregularly. And in terms of the outcome, civil recovery and AOD to the value of 559 million was signed, was signed by the debtors, and criminal referral to SAPS is already investigating a criminal matter in relation to the award of this bursary. And disciplinary referrals, we could not refer any disciplinary action because all the implicated officials left the employment of Denel. Then in terms of bursary, pilot bursary, student number 2 also, same allegation. And here we also found that the bursary was awarded irregularly. Here in terms of the outcome, civil recovery, special tribunal order, the SIU to notify the debtor of the court judgment before garnish order or emolument order is granted. Then in terms of criminal referrals, SAP is already investigating criminal matter relating to the award of the bursary. Disciplinary referrals, we couldn't make any referrals because all the implicated officials left the employment of Dinel. Then pilot bursary student number 3, same allegation that it was awarded in breach of Dinel policy. And the finding is the same, that it was awarded irregularly. Then in terms of the outcome, here there is no possible recovery against the school due to no contract in place between the parties. And because the NEL was aware of the student 3 bursary overpayment. Criminal referral SAPS is already investigating this matter. And disciplinary referrals, we couldn't make any referrals because the official involved have left the employment of the NEL when we concluded the investigation. Then the next investigation progress update relates to PRASA. Here, the background is that in May 2019, the SIU and PRASA concluded a secondment agreement wherein the SIU seconded members to PRASA for a period of 3 months. The scope of the secondment included the following: the collection analysis of investigation report prepared by Werksman, and also the collection analysis of management reports pertaining to irregular and or fruitless and wasteful expenditure identified by the AG, and to advise the Board of Control of PRASA on the matters that may require further investigation by SIU. And subsequent to the analysis of the relevant report, the SIU identified matters that require further investigation and motivated for a proclamation which was proclaimed by the President on the 30th of August 2019. And the procurement included 7 focus areas of the investigation. And this report provides an overview of the investigation conducted. Then in terms of the progress update, the first one we look at is the procurement of Royal Security CC. And the allegation here is that according to Werksman Attorney Forensic Report, the public protector found that the appointment of Royal Security was irregular after the initial contract was cancelled due to underperformance. And PRASA tried to cancel the subsequent appointments, but Royal continued to deploy security to PRASA and protect PRASA assets on the basis of verbal requests from the former GCO, who instructed the head of group corporate security to continue the engagement. And Werksman indicated that Royals appears to be a preferred service provider to PRASA and continually obtain further work through extension and deviation from open tender process. Then in terms of the finding, SIU found that PRASA signed the original contract with Royal Security on the 17th of May 2011. The contract was on numerous occasions extended with the approval of the former GCO. SIU found that the procurement of Royal Security was through an irregular confinement processes, and the SIU concluded that at all relevant time, the appointed GCO failed to ensure that PRASA follow a competitive procurement processes in the appointment of the security services, and a total amount paid to Royal Security escalated to 578.8 million for the period between January 2010 to 31 September 2019. The outcome is as follows: civil recovery. Due to lack of documentation, SIU could not conduct full investigation to quantify any loss by PRASA, and the member who were responsible for safekeeping the records and the documents are no longer working for PRASA. Therefore, we couldn't make any referrals against those members. And disciplinary referrals also, officials involved in the procurement of Royal Security have since left PRASA and are not in the employment of any public service. And 6 criminal referrals against all former GCO has been referred to the NPA for the contravention of the PFMA. The second one is the procurement of forensic investigation services. Here, the Auditor General found that the appointment of Werksman attorney was irregular as he did not follow the competitive procurement processes. And our finding is that on the 6th of August 2015, PRASA signs the terms of engagement with Werksman attorney to conduct forensic investigation in response to remedial action rendered by the public protector. The Board of Control took a decision to request 2 board members to facilitate the appointment of a service provider to conduct the investigation and exclude the executive management from the process. According to the board, this was to ensure that the process is not tainted by the same official that will have been investigated. There was no competitive bidding process followed in the appointment of Werksman, but instead the board member relied on the fact that Werksman was already part of the panel of attorney that were in the database of PRASA. And SIU found that the appointment of Werksman was irregular. Then in terms of the outcome, civil recovery, none, because the service was delivered by PRASA, delivered to PRASA by Werksman and subcontractors, and we found evidence of no overpayment. Then disciplinary referrals, SIU is considering evidence for referrals of the 2 board members for administrative referrals, and criminal referrals, none, because the service was rendered. Then the third one is the procurement of royal security again. Here, the allegation is that various service providers were appointed by PRASA by means of deviation from open tender processes to augment the capacity and improve reaction time for the rolling stock repair for Shosholoza Mail and Metro Lane. Werksman attorney investigated the procurement process and recommended that PRASA should investigate the engagement entered into with this various entity to determine whether the work contracted and paid for was in fact completed by each of the entity and to the satisfaction of PRASA. Then in terms of the finding, SIU established that the CIA is currently under litigation, and the SIU obtained the liquidators report and established that SARS was the preferred creditors in terms of the liquidators report, and PRASA was not noted as owing CIA an amount of 63 million. In general, it means that the finding is that the contract entered with Royal Security and some of the subcontractors was entered through irregularly through a confinement. That's why now we indicated that the CIA is currently under liquidation. So in terms of the outcome, is that due to lack of documentation, SIU could not conduct full investigation to quantify any loss suffered by PRASA, and the member who was responsible for safekeeping of records and documentation are no longer in the working of PRASA. Here, Chair, I just need to indicate that we have done all that we could in order to make sure that we locate documents, and we even went to the extent of checking who was responsible for safekeeping of all these documents. Therefore, out of that process and having gone through, we couldn't find all the documents. That's why we indicate that we couldn't proceed in terms of civil litigation. Then in terms of disciplinary, still we couldn't find the official that were involved in the procurement of royal security because they've left the employment of PRASA and they are not in the public service. And also we could not make any referrals for criminal referrals because we lack documents so that we can able to support any finding that we would have wanted to make. Then the second one relates to Alesco investigation. Here the background is that the Special Investigating Unit is mandated in terms of Proclamation R45 of 2021 in order to investigate the following allegation of maladministration in the affair of Alexco. There is serious maladministration in the affair of Alexco in respect of the marketing, valuation, sale, and beneficiation of diamonds pursuant to agreement concluded between Alexco and service provider, any improper or unlawful conduct by official or employee of Alexco, and this matter was investigated as part of the Judicial Commission of Inquiry into state capture, and the presentation outlines the results followed. Then, in terms of the status of the investigation, we are looking at the 2015 contract awarded to SSI. Here, the allegation is that the contract was awarded irregularly. In terms of our finding, we found that there was contravention of Section 217 of the Constitution, in that no transparency in the briefing session as held by individuals with potential bidder, and no minutes were recorded during the bidding process were kept. And there's a contravention of Treasury Regulation 16A6.2 as no BEC and BAC was established. And there was contravention of Treasury Regulation 16AC.3 as evaluation criteria not concluded in the bid documents and bid evaluation against criteria that was not in the bid document. In terms of the outcome, investigation is concluded and referrals to civil litigation to invalidate and recover the fund is currently under review. And disciplinary referrals, employee involved have left the employment of the PSJV and are not in the employment of public service, and all members who contributed to the loss suffered by Alexco, including those that left the employment of Alexco, will be cited in the civil litigation process. And criminal referrals, in November 2022, a criminal referral was made to the NPA for possible criminal prosecution against PSJV board and management. Then in terms of contract 2016, that is contract awarded to SSI. The allegation is that the contract was awarded irregularly, and the finding is that there was the need for the contract was not clearly defined, and there was contravention of Treasury Regulation in that BAC was not established, and there was also contravention of Diamond Act as SSI did not have a license to sell, purchase, beneficiate, and run a trading house. And there was also contravention of Section 217 in that irregular disqualification of other bidders, rendering the process uncompetitive. In terms of the outcome, civil recovery investigation is concluded. Referral to civil litigation unit to invalidate the recovery of funds is currently under review, where it will be forwarded to a civil litigation unit so that it can be forwarded to the special tribunal. And also disciplinary referrals, we couldn't make any referrals because all the employee left the employment of PSJV and they are not in the employment of public service or Alexco. However, they will be cited in the civil litigation process. And criminal referrals to NPA for possible criminal prosecution against the PSJV board and management is currently underway, and it will be made soon. And now the third phase is looking at the quantification and valuation. Here we're looking at the allegation is that diamonds were undervalued and the SSI sales process were irregular. In terms of our finding, SSI sold the diamonds on auction and held 44 sales for the PSJV over the period March 2015 to August 2020. A total of 271,715 and 98 diamonds currents sold at the value of 1.8 billion was made. Some of the parcels sold were below the market value. An auction invited known associate to invited known associate of SSI, indicating conflict of interest and possible collusion transaction not at the arm's length. And Eastern Hemisphere Trading, director of this entity were employee and director of SSI, whose role included the evaluation of diamonds and running of the tender house. And Representative House, director of these entities were employed by SSI to run the tender house. Joe Gadi Diamonds, director of these entities were employed by SSI to polish the diamonds. These are some of the auctioneers which were invited to attend the auction, whereas they are employee of SSI. So that really shows that there was collusion in the whole process. And the status of the investigation, 90% of the investigation is concluded, and currently they are providing support be rendered to civil litigation referrals, whereby an amount to be recovered is the 1% of the commission paid to SSI for the rendering of the service, which is currently quantified at 25.9 billion. And currently on this quantification, I should just indicate that the outstanding work is the quantification of the amount that will be recovered. Then, in terms of the matters that are finalized and related to the state capture, is the matter relating to the Free State Department of Human Settlement. Here, a complaint was received from a whistleblower who made various allegations regarding the appointment of a service provider to undertake technical assessment of the old township houses roofed with asbestos. Then the SIU applied for a proclamation to investigate this allegation. The SIU was mandated through the issuance of Proclamation R39 of 2019 to conduct investigation into the affair of the Free State Department of Human Settlement in respect of the procurement of or contracting for services pertaining to the identification and removal of asbestos from houses in the Free State, any related unauthorized or irregular and fruitless wasteful expenditure, any unlawful or improper conduct by the employee or official of the department. And the value of the contract was 255 million, and a total of 230 million was paid by the department. In terms of the status, we see that the procurement of the Diamond Hill Trading 71, which is Blackhead's joint venture for the identification and removal of asbestos from the houses in the Free State, was made. And the status is that the investigation is in the supporting phase, whereby supporting is ongoing on remedial action, such as the referrals to the NPA and the disciplinary referrals and the ongoing civil litigation in the High Court. In terms of the finding on this contract, the main finding were as follows. The procurement process in respect of the appointment of a service provider did not comply with the Section 217 of the Constitution. Due to the fact that the procurement process was irregular, the expenditure of 230 million that was incurred constituted irregular expenditure. The amount of 208 million that the department overpaid, that is 230 million minus 21 million. That is the amount which the service provider could have been rendered, constitute fruitless and wasteful expenditure. Then in terms of the outcome, disciplinary referrals, 4 referrals were made against senior official for financial misconduct, for contravention of Section of the PFMA between June and August 2021. And NPA referrals, one criminal referrals was made to the NPA in 2020 against official and service provider for further action. And several official, private, individual, and entity are currently facing charge of fraud, money laundering, corruption, attempted theft, failure to report corrupt activity, and contravention of Section 86 of the PFMA in the High Court. Then in terms of civil action, the SIU and Free State Department of Housing Settlement have issued summons in the High Court for the review of the contract valued at 255 million and the repayments of the amount to the value of 230 million. Summon issued in the High Court against the Free State Department of Human Settlement for the outstanding payment of 25 million, and the Free State Department of Human Settlement, SIU, are defending this claim. SIU is considering civil action to review and set aside both contracts and to recover financial losses suffered by the Free State Department of Human Settlement. Then in terms of motivation for proclamation, this relates to matters which were not covered by proclamation, where we extended the extension to cover some of these matters. Therefore, we have submitted the extension of the proclamation for ESCOM and also for PRASA as indicated by Department of Justice, and also for Transnet, and we also done it for TNA breakfast briefing, and also for AXA contract. So those are the matters where we have prepared a motivation for proclamation so that our mandate can be extended so that we can cover some of the matters which are covered by the State Capture Commission, but they are not covered by the currently issued proclamation. And I think I'll end here, Chair, and hand over now to Advocate Mutivi to finalize some of the slides. Thank you.
Thank you, Mr. Lekgetho, Honorable Chair. As part of the State Capture Commission report, there is a requirement that the state has to implement measures to prevent corruption, maladministration, and malpractices that were identified. There is a clear need for the development of the framework to prevent all this. So in our view, the development of the framework will entail the following, amongst others: the assessment of the causes of corruption, maladministration, and malpractice identified by the State Capture Commission and other commissions of inquiry, such as Nugent Commission of Inquiry into SARS and the Mumpati Commission into the affairs of the PIC. The development of a comprehensive corruption, maladministration, and malpractice prevention framework would include the following, amongst others: taking into account the relevant provisions of the United Nations Convention Against Corruption, such as those in chapters 5 and 6, will require the national anti-corruption strategy provisions to be taken into account. We'll also have to conduct appropriate and focused corruption risk assessments. We have started with the data analytics to identify the presentation keeps up disappearing, Mr. Lekgetho. We've started with the data analytics to identify corruption exposures and trends, and identification of the required controls. Honorable Chair and honorable members, there is a clear indication that there were systemic errors and systemic mistakes that were affecting the system, some deliberate, some as a result of the collusion of the officials, so we will have to identify all of those. The framework could also include lifestyle audits and the role of society, business, labor, government, faith-based organizations, and other stakeholders. The appointment of accounting authorities and accounting officers needs to be reviewed. The integrity framework, including the vetting processes of various business areas. Of course, there's also reference to political party funding legal framework, and the identification of vulnerable sector approach in the fight against corruption. This is but amongst others. The SIU has been tasked by the Anti-Corruption Task Team to lead and coordinate the development of the Corruption, Maladministration, and Malpractice Prevention Framework and the Corruption Measurement Framework. Before I conclude, Honorable Chair and Honorable Members, as you would have noticed in the presentations that Mr. Lekgetho, who is overseeing the investigations, we've got lead investigators in all of these investigations, and we have ensured that we provide the resources that are required, and hence the outcomes that the honorable members are presented with. But one observation is the phenomenon that we are faced with, as you could see, the officials living, in the face of the investigations and before the outcomes. The best that we do, because they would have terminated the employer-employee relationship, the best we do so that we don't really let them get off. We pursue them based on the civil litigation process, and of course, based on whether there is a criminal evidence pointing to them. Honorable Chair and honorable members, you would have seen in various presentations, particularly in the Transnet, in ESCOM, and other presentations, that we do enter into settlements. So the question arises is, are those settlements really ensuring that the state institutions' interests are protected and the public interests are protected? So what happens ordinarily is that the service providers, for example, in the 1064 locomotives contracts, they approached Transnet with the settlement, and the contract is such that we just didn't go into detail, but it appears that the service providers will still be kept. So the settlement is to ensure that the services are unlocked, because there's a number of locomotives that are sitting and not working, and the parts are not being provided because of all these disputes. But the point I want to make to the Honorable Committee is that every settlement is really scrutinized to ensure that the interests of the state institution are protected, the public interests are also taken into account, so that nothing is left unattended. And in so doing, of course, we save some of the litigation costs that would have followed. Honorable Chair and honorable members, this was, of course, pointed out by the Zondo Commission. You would have noticed that there's a various network that has been, uncovered here, particularly the so-called transaction advisors. They were at Transnet, they were at ESCOM, they were at SAA, regiments, and the others. So clearly, that network was deliberate, and we have seen the way that they have really entered into deliberate transactions that were not in the interest of the state institutions. The involvement of boards in various state institutions has also been uncovered. This is really just but amongst others. We are going to be doing quite an intense investigations into the governance failures as part of the systemic investigations, so that we make recommendations on the improvement of the administration and the controls that are required to be implemented. Honorable Chair and honorable members, just for comprehensiveness really around ESCOM, there is a report that has made public news, the so-called Fivers report. Just really for the committee and for the record, ourselves, SIU, and the Hawks, we've looked into that report, and that report has got information that we definitely are looking at, so that we can pursue those indicators in that report. And the Hawks is also hard at work to pursue the criminality that is pointed in that report. On the PRASA side, we are indeed really anticipating that the new proclamation would be signed off. There's going to really be a deep dive into PRASA, because the Zondo Commission report says we need to look at the failures of PRASA and what caused the failures. So that in brief is really the scope, but it really has a wide impact. So once that proclamation is signed, we will definitely ensure that we are prepared and the appropriate resources are identified for the investigation. My colleague mentioned the issue around the lack of documentation, which really seems like it's coming out as a defeat to the investigations. And my instruction to the teams was that we shouldn't just leave it there, because otherwise it's an easy way out for the state institutions to say we can't trace the documents, and then that inevitably stops the investigation. No, we go in and find out what were the document saving requirements, who was responsible, how were the documents lost, and who was accountable, so that we don't just leave it hanging there. But the issue around the documentation, particularly in the PRASA investigation, has become an issue. No, thank you very much, Honorable Chair. We thank the committee. We are ready to take questions. Thank you.
Thank you very much, Advocate Mutibi. And to the other presenter, thank you very much for the work done. It's quite clear that we would not be in a position to take the presentation of the NPA. I think we will invite them to present at the next available time. Members would, those who would be traveling from the parks from around past, they need to start moving towards Parliament. But I will now take questions. Honorable Jelle, Maseko Jelle, Honorable Nibut Duchen, Honorable Werner Horn, in that order.
Thank you very much, Chair. And also, it is still good morning to the team, Entatemo TV and Advocate Atoy. I see here, I just saw here. Chairperson, I really would want to applaud and appreciate the work by the SIU. There's a lot of work done in this institution, and some of the concerns that I was maybe having, the last comment of Advocate Mutibi covered me. But I would still want to hear maybe the report of the NPA in relation to this, because maybe some of the things will be missing for us to be able to ask questions, maybe which are related to the answers that might have been located in the NPA. But for now, Chair, one would want to applaud the good work done by the team and the Advocate Mutibi. And also, Chair, the concern that I was having more, they have covered in terms of the officials that are leaving the government after they have done this, the wrong that has been uncovered. There are a lot of them. And when you look at the monies that are lost in this, there's a huge amount. In fact, the country was going to be able even to pay if we're able to recoup everything, was going to be able to pay our debts, Chairperson. But unfortunately, it won't come back as which wished Chair to have happened. But also, I wanted to find out the question from to the team. It's about these the officials or the directors of these big companies, those that colluded, Chair, and also committed these crimes. I don't hear much about following these companies in terms of the directors and the board members of those companies having to pay back what has been taken from the government. So maybe if they can also come back and comment on that one, because I hear this one. That was the most important thing that really worried me, that one of these officials that have left, and how are we going to get that amount? Because you can see that this indeed, I agree with him, that it was a planned and systematically done. Because if you check, Chair, all these officials, they leave and they don't even, they run away even coming closer to any employment of government, because they know that they were going to be arrested. So, Chair, I think that is my last comment on this, but good job. Thank you very much.
Thank you very much, Honorable.
Chair, I'm sorry to interrupt, but on a process issue, my humble apologies. Is the NPA expected to still remain on this platform, or can I ask colleagues to be excused and attend to other matters and perhaps just leave one or two of them on the platform?
No, I think that will be fine. We would not, because you would not have time to take your presentation today. I think if one or two officials remain, I think we can release the others.
Thank you very much, Chair. I will be leaving. Thank you as well.
Thank you very much. Please,
Okay, good
NTPP, accept our apology. We are just operating under serious time constraints, because today we are also, most of the members are debating. We will be dealing with two bills in the House. Under normal circumstances, we should have scheduled for the whole day, but it was not possible. Our apologies for that.
Noted, Chair. Just to be clear for the next meeting, the NPA only has 15 slides. We've submitted the presentation, which is much longer, about 50. We have a short presentation and about 50 slides that deal with the cases, but we will not go through that in our presentation. That we will take as read for the next meeting. That was the way we intended to proceed today as well. But we will leave the meeting now. Thank you, Chair.
Thank you very much. Honorable Nevot Johan.
Thank you, Chairperson, and good morning to everyone. It's still morning. Thank you to the SIU for your presentation. I just have a quick question. Like Honorable Jele said, the concern about the officials who were involved and then leaving the institution. And I wanted to know, all in all, how many officials have been involved and how many of them resigned or left the institutions. And then those who left the institutions, you said that it will be going for civil litigation or criminal litigation. Now, how many of those officials were successfully litigated against, whether criminally or civilly, or in civil litigation, because like Honorable Jele said, and we're concerned about the money that disappeared, and the money cannot be recovered necessarily, and the officials knew all along that they would be investigated, and then they left the institution, but government needs to recoup that money. So and how much of that money are we able to recoup? Then the second thing you said, that there, in some cases there's no criminal evidence could be found, and I'm trying to understand that, because you continue saying no criminal evidence could be found. So what does that mean? Does it mean that the documents were destroyed, the computers that were taken into evidence were destroyed? Why was there no evidence? I just wanted clarity on that. And then also, sorry, Chair, my last one. I read with regards to SASSA, I'm very, very concerned. SASSA, especially, the most vulnerable get their grants, and if they don't get their grants sometimes, then we read the money is sent back to National Treasury. I'm so curious if the SIU investigated that, why this occurred. And I also read something relating to the new service provider who do the SASSA payments, but unfortunately they couldn't do the payments, or that bigger number, they had a limit, so which also then affects our vulnerable people. And like you said, in that last part, the SIU also looking at the most vulnerable who have been affected about this big money. That's just gone. So I'm just curious, what is the SIU, looking into the payments that are not being made via SASSA? Thank you, Chair.
Thank you, Honorable Governor Horn.
Yeah, thank you, Chair. And let me firstly add my voice to those who have appreciated the work done by the SIU. It is quite clear that the SIU is working in a focused manner in respect of the matters flowing from the Zondo Commission that has been referred to them. And that is exactly what we need in this country. Having said that, Chair, I think it would have assisted somewhat more to have a full appreciation of the work done by the SIU, if specifically in respect of those matters where it is reported that civil litigation has been embarked upon, if timelines could have followed or been part of the presentation, estimated timelines, of course, given the complexities around civil litigation. So maybe if we could be afforded as a committee in follow-up some information as to the progress with matters, specifically in respect of those which has reached the special tribunal or is still to reach the special tribunal. In addition to that, Chair, I would also want to inquire, given the fact that these processes typically do not unfold very speedily, and I'm not now casting aspersions or blaming the SIU, in respect of which of these where they are now embarking on civil litigation or have done so, is there a process parallel or already concluded to get freezing orders into place? So we've noted in respect of a number of the matters, Tegeta for one, where some of the negotiations is now unfolding with business rescue practitioners. It reminds one to an extent of the old saying of easy come, easy go, but also I think it's fairly, I don't want to say natural, but I want to say self-explanatory that if the payments coming to a specific company or entity is on the back of a corrupt scheme, then of course it must follow that this company will also try and put measures in place to move money so that ultimate civil judgments may turn out to be hollow judgments that may not be enforceable. So I don't know to what extent there is freezing orders in place, and if not, why not? And then the last question I have, and that's in relation to more or less the standard response, and the other two colleagues have also referred to it, Chair, around the officials responsible who have left the employment of the different state-owned entities and departments, and therefore disciplinary action is not possible. Now, what worries me about this specific response is that this trend and problem was identified by the President in his response to the Zondo Commission report filed in October 2022. And in that specific response, it was then stated that DPSA, the Department of Cooperative Governments, and the Department of Public Enterprises, along with National Treasury, was tasked to design and implement by April of this year a central registry where, which would then be a database of those who fled from disciplinary action in order to prevent exactly that type of situation I think the Honorable Maseko Jele referred to, which is we don't want any of those collaborators with in respect of state capture to ever again come anywhere near being employed by the state or state-owned entities. So I would have hoped that the report rather should have indicated that these individuals and their names have now been referred to that central register. That's of course on the assumption that it is now in place, and maybe the more pertinent question would also then be whether it is in fact in place, whether the SIU has been informed of it, and if not, Chair, then I would suggest that when we schedule the further meeting to hear from the NPA, that we then invite DPSA along with Treasury and all those lead departments who have been tasked by the President to set up this register to come and report to us as to whether it has been set up, and if not, why not. Thank you.
Thank you, Honorable Ngoda.
Thank you very much, Chair. Chair, it is quite clear that the report has been clear and comprehensive in terms of dealing with the detail of what the SIU is currently doing in relation to the Zondo Commission report. It does seem that there is a committed effort to ensure that that work is done. I've got only one question because my colleagues have covered a number of questions. I'm left with one now. That it is understandable, Chair, that disciplinary proceedings won't be preferred against officials that have left employment. And we get the fact that as well, they are cited as respondents in the civil litigation. But I want to check if are there any criminal charges or criminal cases preferred against these former officials of these entities, because it is my understanding that they have perpetuated crimes whilst at the employment of the state. So I wanted to check if there are any criminal charges preferred against them currently. We understand the DC and the civil litigation matter. Thank you very much, Chair. It was just that from my side.
No, thank you very much. My understanding was that they have indicated on a number of occasions that they have referred those matters for criminal investigations, but they are here to answer for themselves. Members, just before we proceed to responses, two issues. One is the introduction of Advocate Vanara, and then we can have a 3-minute break. And then we can proceed from there. Advocate Vanara. Advocate Vanara would like to see your
Good
face.
day, Chair, the honorable committee members, as well as colleagues. As Advocate Matibi indicated, my name is Dutuzelo Vanara. I've recently joined the Special Investigating Unit as its Chief Legal Counsel. Thank you.
No, thank you very much. We would like to welcome you to this hardworking institution, which is the SIU. We hope that your contribution will take the institution to the next level. We welcome you, Advocate Vanara. Before we take responses, can we have a 3 minutes comfort break? We would come back at 12:10.
Thank you, Chair.
Thank you very much. Advocate Mtibi, over to you and to your team.
Thank you, Honorable Chair, honorable members. I'll start off. Honorable Maseko Jele, we are really encouraged by the kind words. We will send the message to the investigating teams so that they continue to do their best. The issue around the officials living in the face of investigation, it's really, really problematic. And we have pointed that out. I'm really pleased that Honorable Werner Horn has brought it up in terms of the database that's required. We will, of course, reach out to Presidency and DPSA to find out, but I'm sure they can probably come and give an update to the Honorable Committee. That will really, really assist because, and in fact, our preference is that that database should cut across not only public service, it should be public sector, so that it covers, the departments, it covers SOEs, it covers municipalities, because we're seeing this phenomenon across the public sector. Now, so we will reach out on that. Honorable Maseko Jele, the directors of the big companies, I'm really glad that that question has come up. It's important, and I always emphasize to my colleagues internally that we need to be seen to be even-handed. Whether we are dealing with public servants, public officials, private companies, whatever the size of the company, we must be seen to be even-handed. So there's a few examples that I want to cite, and those appear in Transnet and in SAA and in Dinel as well. And then there's another proclamation that we are motivating in AXA, Airports Company of South Africa. There's also the involvement of big banks in this processes. In one matter at Transnet, we are at the stage now where we have prepared the papers to go to the special tribunal, and the bank involved, has really come and raised lots of questions in the process, and that, in my view, is really tantamount to unreasonable delay, and they really are delaying to be held to account. But I can assure you, Honorable Jele and Honorable Chair and Honorable members, that we will not leave it. We will never leave it there. And these big companies and their directors have to be held to account. We are just few days left, and Advocate Vanara is monitoring that process. So we have to make sure that they are also held to account. All the blue chip companies. Another example is in Eskom, ABB, which is an international blue chip company, which was also held to account. And we will continue to make sure that various other big companies which are involved in wrongdoing in these power stations continue to be pointed out and they are held to account. Honorable Nivo Drachen, Honorable Chair and Honorable members, we do have the number of officials that have been identified as part of the wrongdoing and have left, and we've got their names. So with your permission, Chair, and we will ensure that we do it within a reasonable turnaround time, where we can now extract those names from the investigations or the numbers and submit the name to the committee, showing how many are involved per investigation and how many have been cited in the civil litigation and how many have been referred for criminal consideration. Just to cite few examples in Eskom. In Eskom, there is a civil suit that has cited the former CEOs, the former board members, and 1 executive authority member. So all of those are no longer with ESCOM, but we ensure that we continue to monitor that. But Chair, we will submit a comprehensive list, which will then submit to the committee. How much money could be recouped in terms of the civil litigation? Honorable Nivo Drachen, there's quite a number of millions and billions that we have indicated per investigation. Honorable Chair, what we will do as part of the exercise, we will then have to extract all those civil litigation matters and indicate the amounts to be recovered. The other related question, as I now just compare with the question raised by Honorable Horn, we do admit that we need to indicate sort of estimated timelines. And Honorable Chair, on this one, we will also indicate whether the matters are in the High Court or in the Special Tribunal, and the timelines that they've been on the roll, and indicate, why is it that the rolls are not moving. We will prepare that. The issue around why were there no criminal evidence. My colleague, Mr. Lekgetho, will probably come in instances where there were no documentation found, but he did really explain that in instances where there are no documentation, we go further. We go further and really inquire who was responsible. There's a related investigation that Honorable Nivo Drachen refers to, the SASA investigation. Honorable Chair, while we do not have the details now, we can assure the committee, the honorable members, that we are investigating in the SASA. We have seen headlines where issues are pointed to SASA. The team will go back and ensure that the investigation is reviewed and see whether these matters can be included in the current investigation. And Honorable Chair, we will be ready to give the committee an update, a full update on the SASA investigation. Honorable Werner Horn, again, thank you very much. We really appreciate the kind words of encouragement. I agree that we should indicate the timelines, as I said, and we will do so. The civil litigation team will extract, a full civil litigation report, so to speak, identify the timelines, the values of the contracts that are being attacked, and of course, the issue whether we will be able to indicate possible recoveries. I'll check with the civil litigation team, because that is subject to what we call just and equitable adjudication by the courts, but we will indicate the values of the contracts. Now, another important question, and thank you for that. Which of these civil litigations, are parallel to the freezing orders? Honorable Horn, I think we need to concede that, and I've said that to the team, and that Mr. Lekgetho will come in. I've indicated to the team that, again, in the view of being even-handed, treating every investigation the same. I mean, if you consider various of other investigations that we have done, the lottery and the others, when we have got findings that we have made, and we are going to the civil court to cancel contracts, there is profiling that happens. Financial profiling that happens, so that we are able to freeze the assets accordingly. And Mr. Lekgetho may have just a comment on that. I have instructed the teams to do that, so we should be able to see the outcomes and the actions being taken, because of course that is clearly to address one objective, that those whom we are acting upon have the propensity to dissipate the assets. So we want to mitigate that risk. We can on the next occasion indicate to the honorable committee the kind of work that we've done there. The officials who left in the face of investigations, the issue around the database, I'm really glad that the honorable member brought that up. That is going to be a very critical, a tool to ensure that we follow through on all of these people, but we will follow through to DPSA, presidency, and treasury around the establishment of that database. Honorable Ngola, again, thank you very much for the kind words. Officials who left, are there any criminal charges? Yes, indeed. We have, as the Honorable Chair indicated, we have said, even though they are leaving of the state institutions, resignations, they terminate the employer-employee relations, we make sure that where there's evidence pointing to them, they are pursued through the NPA and the Hawks, and we assist in that process. There's a number of them where we have made those criminal referrals. Honorable Chair, I really hope that I think I've covered all the questions. If there's still one that's outstanding, we can respond to that. Thank you. Or maybe Mr. Lekgetho, do you want to come in around the financial profiling to ensure that we freeze in the process of civil litigation?
Thanks, Advocate. Yes, on the issue of financial profiling, what happened is that once we investigated, we found irregularities. And during that process, when we identify irregularities and we are in the process of taking the contract for review at the special tribunal, we follow the money. And once we found that some of the assets that were the money which was taken from state institution used to buy assets, and there are some irregularities, we do go to special tribunal so that we can freeze those assets so that the money is not dissipated. So that's the process that we do. And also it's coupled with some of the official where we have identified irregularities or we are investigating and they resign. If they resign at the particular before and the investigation while it's ongoing, we also go to court to make sure that we freeze their pension. In most instances here, they left before we even came in. That's why we could not freeze their pension. But where they're involved and we see some irregularities, we check around their profile to check around their assets so that we can able to know how much we can able to recover. If they are tangible assets, we freeze them pending the litigation so that we can able to get money out of those assets. Thank you, Advocate.
Okay, thank you, Mr. Lekgetho. Honorable Chair and honorable members, that's our response. Thank you.
No, thank you very much to you, Advocate Mthibi and Mr. Lekgetho, and to everybody who has worked on this presentation. We are always pleased when we have to listen to the SIU, the amount of work that you do. It really pleases us to have an institution like yourselves in our stable. Your contribution to the fight against crime and corruption, it's noted in a positive way. Thank you very much. We will follow up Honorable Horn on the suggestion that you have made that when we have the next round, the other entities that we should invite, we will follow that up. And also, Advocate Mthibi, you said that you will be supplying us with this information within a reasonable time. Can you be a little specific?
No, thanks. Thank you for that, Honorable Chair. If it's permissible, can we submit it within 14 days?
Yes, no, that will be fine.
Thank you very much. We'll ensure that it reaches the Secretariat of the Portfolio Committee in 14 days. Thank you.
Thank you very much. And I also wish to indicate to members that if you read the report of the NPA, there are quite a number of names that are in that particular report that are being investigated criminally. But it will also help that we read the two reports together. We will communicate with the NPA and SIU and the other institutions that have been suggested for the next round of our engagements. And thank you also to the department for the report that they have given us. Thank you very much. You are now released. Members, can we just have a few minutes just to talk about tomorrow?
Thank you, Chair. Thank you, Honorable Chair and honorable members. Thank you.
Thank you very much.
Thank you.
Members, for tomorrow, our day is quite heavy. We will be dealing with the report on Judge Mutata. We will also be dealing with the issue of shortlisting. And we would also be getting a report, in fact, the briefing from Treasury and the Ministry of Justice on the issues pertaining to the information regulator. But specifically on the issue of the shortlisting, what I would suggest, I've asked Ms. Silkstone to prepare sort of a document on the criteria, like we did with the public protector, the one that we have just interviewed, those who serve in that particular committee. I think members would be aware that there was an inquiry as to what criteria did we use to shortlist. So I thought that before we shortlist, we should have that short discussion or a discussion which will result in us adopting a criteria before shortlisting. If there is no if there is no objection to that, can I propose that we do it that way? We have that presentation of a criteria, and members would engage on, and then if we agree, then we can shortlist. But I wanted to bring to attention that tomorrow we'll have a tighter program. Any comments?
It's fine, thank you, Chair.
Thank you. Any objection? No objection. Thank you very much, members. The meeting is adjourned.
Bye-bye.
Bye-bye.
Recording stopped.